Madam Court Reporter?
Yes, sir.
All right, well, I've considered this matter, and I want to make clear that when I speak of prosecutorial misconduct, I want to make certain that you understand that I'm not speaking of members of the prosecuting attorneys per se, but because of state actors for whom the state is responsible. Under the case of Kyles versus Whitley, this case alleges that the husband of the deceased murdered her, and the defense claims that the deceased committed suicide in part because she was still emotionally distraught by the suicide of a previous husband. And the date of this incident was right around the anniversary date of that suicide. This was a very unusual and dramatic suicide, and it was known to family members that the deceased never got over it and had a very difficult time emotionally around the anniversary of that suicide. The critical issue in this case was that the deceased mother went to the deceased home several days before this incident and found the deceased in a very emotional state, and she told her mother that she wanted to kill herself by hanging. But she did not want to do that to her children, and the mother was so upset that she wanted to have her hospitalized. And after the deceased died in this case, the mother has now testified that she told the lead investigator about that incident within a few days. The lead investigator denies that she told him at that time, and he buttresses his story by pointing out the mother hand wrote out her statement, and she did not mention this prior statement or this prior incident in the written statement. Well, the defendant was indicted at the first trial, ending in a mistrial. The mother did not mention the prior incident at that trial because she was cut off by the prosecutor when she started to talk about what the deceased said. The prosecutor testified that she cut her off because of hearsay concerns. I note there was never any attempt by anyone to allow the mother to testify about the deceased statement under 8033 under our rules of evidence, so the court never ruled on it. But while it was known to all that the deceased suffered from severe drug and alcohol abuse and was being treated by a psychiatrist at the time of her death, evidence was presented at trial of the same. It's very troubling that the evidence that the deceased made specific threats of wanting to kill herself just days before she died. This information was kept from the jury. By state action or inaction, had the defendant been convicted, this court has no doubt it would have been considered a Brady violation, and the defendant would have been granted a new trial. The beginning of a new trial is exactly where we find ourselves today. The state argues, with some authority and precedent, that basically this court should treat it as the equivalent of no harm, no foul, and that now that this information is known, it can be presented to the jury, who can evaluate it and give it whatever weight it determines it deserves in arriving at a verdict. Indeed, this court believes that it is a choice among several that would no doubt be upheld on appeal if this trial were to go forward and the defendant was convicted. However, this court believes that our courts should demand better from the state, and to simply allow this trial to go forward with so many witnesses, such as pathologists, having been denied the opportunity to have this critical knowledge available to them when that material was fresh, amounts to a foul with a harm. Therefore, this court is quashing this indictment without prejudice and ordering that if the state wants to retry the defendant, it is to do so only after the case has been resubmitted to a grand jury, who shall have the benefit of the full measure of evidence this matter deserves. This court recognizes this is an unusual remedy However, this is an unusual case. This court urges the Attorney General to present a fuller case to the grand jury than is usually done in state court in South Carolina. The goal is to do justice, and this case deserves a fresh restart in order that the citizens of South Carolina can have full confidence in whatever the jury's verdict may be. It is so ordered. All right?
Thank you, Judge. We are grabbing an exhibit to supplement into the court record of a text message that was shared on May the 12th, which would have been, I believe, the same day that they're alleging this happened, where the victim says, said to Michael, "I'm telling you that I love you. I'm shooting myself in the woods." That is a specific example of her saying that she's going to kill herself, which was one of the reasons why you stated that, Judge. So we just want to supplement that into the record since that was turned over in 2016 to them as well. So we will be adding that as a court's exhibit.
Judge, likewise, we have the videos that were played during the hearing on a thumb drive labeled as court's exhibit number 4 that we believe also needs to be photographed.
All right? Now, I have quashed this indictment. Therefore, there are no charges pending against Mr. Colucci at this time, so there's no longer a bond on him, and he does not have to have electronic monitoring. If and when he is re-indicted, then bond can be addressed at that time. All right? We're adjourned.
Thank you, Your Honor.
I'm going to go address the jury.